Excuse me. All right. Welcome, everyone. Today we're going to cover what we typically cover in 2 sessions. So this is going to be a compressed treatment of discipline, and we're going to talk about dispute resolution. And the idea was to kind of hit the highlights for both of these. Your outline, the materials that you've been sent, are comprehensive, and so we'll have a lot more information in the materials that you have. We will take a break. I am just getting over pneumonia. I will need a break. I might need several breaks to have a coughing fit, but we will take a break once we get through the discipline. So I'll just give you some visibility on that. My hope is that that's around 10 o'clock. And just so that you can get yourself, refresh your caffeine, or answer a million emails that are coming in while you're doing this, or whatever you need to do during that time. So with that, we're going to start with discipline. And so just to give you an overview of what we're going to talk about, we're going to start with the general rules, excuse me, that govern student discipline. Very, very short treatment of that, because I want to move really quickly into what the special ed rules require. I will take questions throughout, so feel free to pop those questions in the chat. I cannot see the questions because I see myself, I see the slides, and I just can't see the questions while I'm presenting, but Erin, I think, is going to assist in just letting me know if there's a question. But if I don't get to your question and Erin doesn't see it, just feel free to take yourself off mute and just say, hey, Laura, I have a question, and I will be able to see you and address those questions. There is a lot of cases in the materials that I sent. I don't have time to go over all of the cases. There is a resource. But if you have any questions relative to any of those, just ask me. So just as a level setting, I want everybody to think about the difference between punishment and discipline. This is a philosophical framework that my hope is that you can kind of orient yourself to, so that you can not only do your job effectively, but also think about those that you interact with, either at the building level, in the classroom, parents, central office. And if you think about what is the difference between discipline and punishment. So discipline, well, let's start with punishment. Punishment is something that, somebody does something and you respond to that. So it's a quick response. It is intended to stop the immediate behavior. It focuses on the action that you are observing, not necessarily the cause of that action. And, studies suggest that it doesn't affect long-term changes in behavior. So that's punishment. Discipline is an approach to changing behavior through evaluating, planning, and teaching. It provides appropriate consequences for misconduct, and it results in long-term changes in behavior. And if you think about discipline, where does that word come from? If you look at the root word of discipline, it comes from the same root word that talks about disciple, and it's really teaching. That's what that root word means. So it is a learning process that provides the student with the skills that are necessary to manage behavior. So if you think about what is happening in your districts, and maybe this would be an opportunity to pop something in the chat. You can do it anonymously, or, if you want to out yourself. What do you think you run across most often when you're dealing with discipline situations? Is it actual discipline, or is it punishment? And if you say to yourself, well, it's probably punishment, just know that what I'm going to talk about today is the discipline approach. That is the approach that the law requires, particularly for students with disabilities. And that's what we're going to focus on today. So if philosophically what you see in your district is more of a punishment approach, and what might result in long-term changes in behavior as a discipline approach, be thinking about how you can orient your colleagues and your teammates to that discipline approach. So let's get into our material. So there's some general principles, excuse me, that apply to all students. So we need to think about what laws, I think that's the first thing, what laws affect, I think that might be the first slide, Maya, what laws that affect student discipline. So there's a lot of different things. So we have case law, we have the IDEA, we have state statutes that affect student discipline. We have board policies. Your board is going to have policies on all of these things. And the quintessential Supreme Court case, which is our next slide, is Goss versus Lopez. And Goss versus Lopez really talked about that for student discipline, students need three things. They need notice, an opportunity to be heard, and an appeal. So those are the procedural requirements, those safeguards, and those happen through what we think of in our schools, which is that notice of intended suspension or notice of intended expulsion, that notice of what conduct is prohibited, which is your student code of conduct that's posted, hopefully, in a central location and made available to students on request. So that's notice. An opportunity to respond is that here's the notice of intent to suspend. What do you have to say for yourself? And the student responds. So that's an opportunity to respond. And then the appeal rights, then they have that ability. So there is general discretion that we have on our next slide that is afforded to the schools, that once something comes to the courts will typically not second guess the discretion that school officials have and the decisions that they make regarding student discipline, unless there's some violation of the process. So if you don't follow that, giving them notice and opportunity to respond and their appeal rights, if you don't follow your policy, many courts won't give you that discretion. So when we think about, and on their next slide is about that constitutional due process, those things are woven in notice, an opportunity to respond, and an appeal. Those things are woven into our state statute. So our state statute is 33-1366, and that's where all of the procedures that you'll find in your board policies come from, but they're also grounded in these standards that came from case law. And those standards that come from case law says things like, you can't have rules that are vague or overbroad. They have to be specific. That's why your student codes of conduct shouldn't say things that are subject to interpretation. A dress code shouldn't say inappropriate dress is not going to be tolerated. Well, what is inappropriate? So you have to make sure that those rules are school related, that they're clear, that students understand what conduct is prohibited. For example, the state statute requires that if students might be disciplined for off-campus misconduct, the rules have to specify that. And you can discipline for off-campus misconduct if the misconduct is related to activities that have occurred on school property. So an extension of a fight that occurred on the bus, and then it occurs in the community, or that is directed at a school official or their property. So for example, principal is getting a coffee at Starbucks, and students see that the principal's at Starbucks and they slash his tires. That would be off-campus misconduct that if your board policy authorizes it, you can discipline the students for that. So we talked about notice, we talked about an opportunity to be heard, and then we think about these appeals. And so there are appeals that go either to the board or the Board of Education's designee, both from a suspension and an expulsion. And the rules for all of these things, the notices, the opportunities to be heard, and the appeal rights, those apply for students who are protected by the IDEA, so students with disabilities, and non-disabled students. And so I just wanted to give that overview of those things that apply to all students, regardless of their disability status. Now, students with disabilities have some additional protections. And on our next slide, one of the protections that I wanted to talk about is the prohibition on non-discrimination. So discrimination can occur when you engage in disciplinary practices that are different. So you might discipline a student with a disability in a different way than you would discipline a student without disabilities. Giving a harsher penalty to students with disabilities than those to non-disabled students. And then one of the things that I want to talk about is making a disciplinary change of placement for a student who has a disability in response to behavior that's related to the student's disability. Okay? An easy example of this is if I'm having a seizure, I'm lying on the ground, I'm having a seizure, and I can't control my body, and the principal comes up to me and tries to support my head, hold me so I'm safe, not flailing around, roll me on my side, whatever the person does, and I kick the principal. Now, technically, have I assaulted the principal? Probably. Assault is like an unauthorized touching that could cause harm. But we wouldn't think to discipline that student for behavior that is caused by their disability. That rule comes from Section 504. So know that if you have students who are eligible for 504 protections, you cannot make a disciplinary change of placement for a student in response to behavior that's related to their disability. And before you remove a student who's protected under Section 504, you have to, before you remove them for more than 10 days, you have to conduct an evaluation. That evaluation is going to examine the relationship between the disability and the behavior. So that manifestation review that we're going to talk about in IDEA, that also applies to Section 504. And then finally, I want to talk about protection in the discipline process from discrimination, and that could be in the form of bullying. So students with disabilities, if they're being bullied because of their disability status, they also have protections there. So what you need to know about this is that those individuals who deal with bullying, that if somebody's saying, I'm being bullied or harassed because of something related to my disability, know that that is something that needs to go outside of your bullying process and move straight over into your civil rights, non-discrimination, harassment process. You probably have in your board policy a separate investigation procedure that applies to anybody who says, I'm being bullied or harassed based on my race, my gender, my disability status, my national origin. That is no longer just straight up bullying that a person is going to be subject to the regular bullying process. It actually has to have an elevated process that is likely not the building principle. Okay, I'm going to scroll over to a different screen. I see that maybe there's
there is a question, Laura. If a 504 student is suspended more than 10 days, you have to conduct an evaluation for a suspected disability in addition to the MDR?
No, the evaluation is the manifestation review, and it's not over 10 days. You actually have to do that evaluation in Section 504 before the 10th day. So the evaluation is looking at the relationship between the disability and the conduct. That's essentially a manifestation review. Same thing. Comes from Section 504. That's where it originated. Okay. If there's more questions related to that, just ask. So bullying can be not only an indicator of disability discrimination, it can also be an indicator that the perpetrator of the bullying might also be someone who's entitled to protection. So sometimes individuals who are engaging in what appears to be bullying behavior, it can also be students who don't understand social norms and rules. So it might indicate a child find issue. So just understand the relationship between bullying and those discipline protections for students with disabilities. All right, we are going to move right into the framework for not discrimination, discipline. My brain is not working. I've taken a lot of hits of this inhaler, and it is just a really regular inhaler. So we're going to get into the framework now. Very often I am asked, hey, why don't you just give us a flow chart? Why don't you just have, if this happens, then do this. If this happens, do that. And, maybe like 5, 10, maybe more than 10 years ago, the Ohio Department of Education actually had a flow chart. And let's just say, in my opinion, the flow chart was not complete. It is no longer up on the ODE's website. But when I tried to make a flow chart of this, it was like 4 pages long, and it had arrows going all different ways, and you had to go like page 3 and then, go back to page 2. It wasn't really a functional flow chart. So instead of a flow chart, I want to talk to you about a framework. Okay. And so I think our next slide is this framework that I'm going to advocate. And the framework starts with thinking about the FAPE standard. So where we get these rules and the basics for these rules comes from the definition of FAPE. So when you think about a free and appropriate public education, that is defined as including delivering services to students even though they've been removed. So in the definition of FAPE, it says that a free and appropriate public education must be available to all students with disabilities residing in the state between the ages of 3 and 21, including children with disabilities who have been suspended or expelled. However, a school does not need to provide services to a student with disabilities been removed for 10 school days or less in that school year if services are not provided to children without disabilities who have similarly been removed. So there it is. The FAPE standard talks about that you have to extend services to students. So there is no set of circumstances. And this may be a hard thing to swallow for superintendents or board members or others who may be outside the special ed process. There is no set of circumstances under which you do not have to serve a student with a disability who's engaged in misconduct. Regardless of the misconduct, you still owe them services. And the rule says you cannot provide them services for 10 days or less in that school year if services are not provided to children without disabilities. Now, that's what I've been saying for years and years. It is not a requirement. Some people have called it the FAPE-free zone, those days 1 through 10. But I'm going to be very deliberate, and I'm going to have a very dramatic pause here. But if you are a district who has adopted those model policies and procedures that the Ohio Department of Education told you must adopt or develop your own in March, just know if you have not read those carefully, another dramatic pause, if you've not read those carefully, there's some interesting language in there about providing services to students with disabilities if they have been removed on a short-term basis for less than 10 school days. It doesn't say it's required, but it is encouraged. And so if your board has put their seal of approval on that, just think about how that can be used in a challenge about not delivering services in days 1 through 10. Now, again, the language says, although not required, okay? But some districts are going through those model policies, and they are identifying the things that are aspirational in nature and removing those things that are not legally required under the applicable statute or within the case law. And so I'll just give you a preview. There are some things in the model policies that seem to go beyond what is legally required in this section about serving students 10 days or less, in the section about destruction of records, in the section about extended school year services, and in the section about independent evaluations. I would be, if you are concerned about this, I would be contacting your legal counsel for further guidance on how to address those things. Okay. That was part of the detour of something current that's happening. So remember when I talked about that the discipline approach versus the punishment approach? Well, the IDEA encourages a proactive approach to managing student behavior. And so, you know, that you see that in the context of things like functional behavioral assessments, behavior intervention plans that are there to be positive, making goals in the IEP related to behavior. And so when you think about this FAPE standard, that FAPE standard includes teaching students with disabilities how to manage their behavior. So just like you wouldn't say to a student who is having trouble reading, well, I see they're having trouble reading. Why don't you just stay at home until you can, you know, come back to school when you can read well? You know, think about that from a behavior approach. You are having problems managing your distress tolerance in school, managing your ability to filter out triggering sounds or interactions. And so you're very reactive in the school environment. So saying to them, well, you know, why don't you come back when you have the ability to manage those things is kind of contrary to the discipline approach. So we know that you're doing functional behavioral assessments. We know that behavior intervention plans are intended to be positive. I think we might be on the next slide. Let's see what's next. Oh, there we go. Our functional behavioral assessments and our behavior intervention plans. Know that there was guidance from OSERS in 2022. And, you know, it really clarifies that the FBA is used to understand the function and the purpose of the behavior, to understand interfering behaviors and factors that contribute to the behaviors. So this is that proactive approach. And then last November 2024, OSERS issued a guidance document talking about functional behavioral assessments. One of the interesting things in that document is that it called into question, and actually probably, I think, resolved the question as to whether or not you need consent to conduct a functional behavioral assessment. There had been a document that I think it was OSERS or OSEP had sent out that suggested that parental consent was required because a functional behavioral assessment was an evaluation. And I have been advising, many people have been advising that based on that, you need to have consent for an FBA. There was then subsequent case law that suggested that doesn't make a lot of sense because the procedural safeguards section talks about consent in the context of an evaluation to determine eligibility for special education services. And then FBA is not that. And so this case law came out, and the federal government responded to that case law and said, we're going to reconsider our guidance. They didn't say how they were going to reconsider it, but they said we're going to reconsider it, revisit it. And in November, so, you know, several months ago, they did issue this guidance document. And in that guidance document, if you haven't seen it, I would get your hands on it. I believe it's referenced in our materials. But in that, it said, if you are conducting a functional behavioral assessment as part of an evaluation to determine eligibility, yes, you need consent. And that's the time that consent is required. So it suggests to me that in other situations, when you're doing a functional behavioral assessment to better understand what strategies to use in a classroom to manage behavioral control in the classroom, that is not considered an evaluation for purposes of determining eligibility, and you can conduct a functional behavioral assessment without getting consent. Okay, so that is something new that I wanted to highlight in addition to the model policies. All right, so our functional behavioral assessment is something that would be identifying the problem, observing the student in various settings, collecting data, developing your hypothesis about the cause of the behavior, testing it, and then, presenting the conclusions. A functional behavioral assessment would be appropriate anytime. A functional behavioral assessment is required when discipline is a change of placement. So it is something that you would have to do when you're proposing something that constitutes a disciplinary change of placement. Okay? We will talk about what a disciplinary change of placement is when we get into that in a little bit. Who's qualified to conduct a functional behavioral assessment? There is no specific qualifications. You can have somebody who has qualifications like a BCBA or a school psychologist or a psychologist. You can have somebody do it that way, but there is no, there's no technical requirements. School districts are required to work to have people who've had appropriate professional development or training or technical assistance, so that they can school staff can conduct an FBA. But there isn't any, requirement for a particular bunch of letters after somebody's name. Behavior intervention plans in that guidance document, behavior intervention plans were addressed in that November guidance document. And the behavior intervention plans are intended to manage behavior, to provide teaching strategies for students who can develop independent skills to manage their behavior, and to reduce the number of students who might need more complex, resource-intensive interventions. So the kids who might need outplacements and things like that. Excuse me. So your behavior intervention plans have to be positive. They have to be proactive. They have to be in writing, it's a written plan, and they have to be individualized to that student's needs. So it's not something like where you would say, oh, we have this classroom management strategy where we move the clothespin on the line and we have red, yellow, green days. It would need to be individualized to the student. Student might respond to the red, yellow, green, or they might not. You just have to have consideration and make sure that there's been an individualized approach. Let's see. Know that even if a student is engaging in behavior that's not externalizing, not disrupting the class or throwing chairs or being insubordinate, that, you would see that behavior. But remember that the requirement to address behavior applies when the student's behavior interferes with their learning or the learning of others. So something that might interfere with their learning is shutting down behavior or withdrawal behavior or not completing homework or being oppositional and not, at home and not completing things that need to get done. So avoid not coming to school. Those would all be behaviors that interfere with their learning, not necessarily the learning of others, but with their learning. So as you're going through the check boxes and determining when do I need to check the box? Think about if there is the student engaging in behavior that's interfering that particular student's learning. Do we need 504s? Do we need a behavior plan for 504s? That can be something that is required. If a student has behavioral issues and needs that support, that can be something that's provided under Section 504. All right. There is a whole section in your materials on restraint and seclusion. I don't have time to cover all of those things. I will just suggest that there is a big section of your materials that talk about restraint and seclusion. So if you need the resources, the references to the administrative code, the summary of that, it's all in your materials. But I'm going to move into our framework. I promised you I'm going to give you this framework for thinking about student discipline. And this framework really requires you to ask 4 questions. Always, always 4 questions. Anytime you think about, somebody calls you about, you're consulting about a student with a disability or a suspected student with a disability, and any type of disciplinary removal is contemplated, I need you to always go back to these 4 questions, okay? These are in your materials. Question number 1. This is the easiest question. Is the student currently identified as a child with a disability? I think that's our next slide. Is the student currently identified as a child with a disability? What does that mean? Well, does the student currently have an IEP? Okay. Student has been evaluated and found to meet the eligibility criteria as a child with a disability, and they're entitled to the protections of the IDEA. So, is there a document? It's called an IEP. This is easy. Yes or no, okay? If the answer is yes, we're going to move on to question number 3, but if the answer is no, we have to linger a little bit with question number 2. Question number 2 is, if the student is not currently identified, should they be considered a child with a disability? What is this really getting at? This is getting at child find. This is getting at, did we as a school district fall down on our obligations regarding child find? Did we not notice something? Did we not take action in response to something? Did we not follow the right procedure when we did have some sort of knowledge of a suspected disability? Okay. Now, I'm going to get into what does it mean to have knowledge of a suspected disability? Because if this is a child find issue, once you have knowledge of a suspected disability, you have to kind of respond to that. Okay. So the first is your knowledge, and the district then has to do, 5 different things to respond. But when do you have that knowledge? What is triggering that knowledge? And I like to use this analogy, and apologies to everyone who has heard this before, because I say this every year because I just love the analogy. Someday I will think of something different, but I've been told that people remember this analogy, so I'm going to continue to use it. Okay, where's my visual? Yellow Post-it note. Okay, yellow Post-it note because I'm from a certain era and I love candy. You don't know that. It's a thing, it's a problem that I have. Willy Wonka and the Chocolate Factory. Do you remember that movie? Do you remember the golden ticket? That's why I have my yellow Post-it note. So this is my golden ticket. So we had those 4 kids. Fun fact, my child played Violet and got to blow up as the one of the 4 kids. Anyway, fun fact about me. Another fun fact, I have dressed up as Willy Wonka for Halloween. So yes, I love this movie. And of course, it's the Gene Wilder version, because the Johnny Depp version is just not something I can connect to. But in the original version, all the kids get their little golden tickets. They are waiting to get into the room. And they are just so eager because they know that once they get into that room with Mr. Wonka, they are going to see, lollipop trees and chocolate rivers and, candy cane lamp posts and all of the things. But they all have this golden ticket. And that's what gives them access to all of this great, wonderful stuff. Well, you probably have students who have in their back pocket a golden ticket. And what that golden ticket gives them is a chance to have all of these protections of discipline. Okay. And your job is to know who has the golden ticket and who does not. How do you know that? Well, there are 3 ways that you get this golden ticket. And if one of those 3 ways happens, the district is deemed to have knowledge of a suspected disability and is required to do a whole bunch of things. So the first way that you are deemed to have knowledge of a suspected disability, and this knowledge has to be before the student engages in the behavior. So when somebody calls me and says, this student engaged in this behavior, and the parent is claiming that they're entitled to, discipline protections, or that they should have been treated as a child with a disability, I am going to ask questions to determine, do they have the golden ticket? My first question I'm going to ask is, did the parent express concern in writing to the teacher, to an administrator? Did they express concern in writing that the child may be in need of special education and related service? I have a concern, my child might need special education. can write that in an email to the teacher, and you might not know anything about it. So that's the first. And if they did, they got the golden ticket. So your job is to train teachers and administrators that if a parent expresses concern in writing that the child is in need of special education and related services, do not sit on that information. Do not, press delete in the message. Do not just hold that onto that. You have knowledge and you have to do something about it. So that's question number one. Did the parent express concern in writing that the child is in need of special education? The second way that you get the golden ticket is if the parent requested an evaluation of the child. Does not have to be in writing. That could occur at a parent-teacher conference. Nobody would know anything. If the teacher didn't do anything with that, student has that golden ticket. Okay. Third way is that if the teacher of the child or other district personnel express a specific concern about the pattern of behavior demonstrated by the child to somebody who can do something about it, to the director of special education or another supervisory personnel of the school district. So it's not the lunch lady expressing concern to the bus driver. It's somebody expressing concern to somebody who's in charge of doing something about it. How could that happen? That could happen if you're convening IAT meetings. Okay. So know that when I'm asking, is the child currently disabled? Because they're entitled to the protection, so they have an IEP. If not, we're at question number 2, should the student be considered a child with a disability? You have to ask the questions, did they get that golden ticket? Either because the parent expressed concern that they might need special ed, the parent requested an evaluation, or school staff expressed concern to somebody who can do something about it, about that child's behavior. Okay. So those are the 3 ways you get this golden ticket. Okay. But just like there are 3 ways that you get the golden ticket, there are 3 ways that you can not have the golden ticket anymore. Okay. And I'm going to answer this question and then I will tell you about those 3 ways. So let me see. If we are addressing behavior issues using MTSS, can't see the rest of it. Erin, what does the rest of it say?
Would that give them the ticket?
If you are addressing behavior through MTSS, and the teacher or other district personnel have expressed specific concern about this pattern of behavior demonstrated by the child directly to the director of special ed or other supervisory personnel. So I'm going to be asking, we're addressing a behavior through MTSS. Did we bring in administration so that we're having a conversation with supervisors? The answer is yes. Yes.
And what about if a student has a 504 plan? Is that a golden ticket?
If a student has a 504 plan for behavior,
it doesn't say, it just says would it hold the same for a section 504.
So remember, a section 504, we're only talking about IDEA. Remember, in section 504, you always, before the student is removed for 10 days, you have to conduct a manifestation review. So those kids are already, no matter if they are on a 504 plan for a bee sting allergy, for diabetes, a seizure disorder, or a mental health disorder. It doesn't matter what they're on a 504 plan for. Every student who's determined to be eligible under section 504 has to go through that evaluation before there is a removal for more than 10 days. So we wouldn't even need to be talking about the golden ticket, because if they've been identified under section 504 for anything, you have to evaluate the relationship between the behavior and the disability. But under IDEA, students who are currently not eligible and might be eligible, that's when you're thinking about this golden ticket concept. So I said there's 3 ways to get the golden ticket and 3 ways to just get rid of the golden ticket. So the first way you get rid of the golden ticket is, we get the knowledge, the parent expresses concern in writing, okay? And we do something about it. We respond. We respond by sending a note and saying, yeah, we heard that you had expressed some concern about the child's potential need for special education. We would like to convene a meeting to talk to, we're going to consider that a referral. I'd like to convene a meeting to talk about whether or not we suspect a disability. You do that. You engage in that process. You propose an evaluation for the child, and the parent says, I am not going to give you consent for an evaluation. Done. Okay. You did something about it. You toss the ball back to the parent, and the parent says, no, I'm not going to give you consent for an evaluation. So the golden ticket is gone. Second way that you get rid of the golden ticket is that you go through the process. Maybe you get consent from the parent, and then you propose an IEP, and the parent says, I'm not going to give you consent for the IEP. So again, golden ticket goes away. And then the third way that you get rid of the golden ticket is that you go through the evaluation process. You get consent, you go through the evaluation process, and you determine that the student isn't eligible for special education, and you complete that evaluation and you give prior written notice. The golden ticket is then gone. So you have to be doing something about it in order to get rid of that golden ticket. What does not get rid of the golden ticket is if you convene a meeting, you do a referral, and you say, we don't suspect a disability, we're not going to test. That doesn't get rid of the golden ticket. You're allowed to do that. It is a legal process, but they still have that golden ticket in their back pocket. So that's how we're level setting who is entitled to these protections. The kids that have take a drink. There are kids that have the IEP, and there are kids that arguably might need the IEP, but you haven't gone through the evaluation process to find out. All right, so those are questions number 1 and question number 2. I think there's a new question. Let's see. Did I answer them all?
What if we don't suspect a disability and then put in place accommodations or interventions to address? Does this get rid of the golden ticket?
Nope. Only the 3 things that I discussed gets rid of the golden ticket. Legally. All right. Next question is, and this is also one that warrants a more in-depth conversation. So the next question relates to, what is the nature of the intended disciplinary action? And so this is related to, what do we think is going to happen here? Is this going to be a long-term removal? Is it going to be a short-term removal? Is it something that we think is going to be no removal, like it's Saturday school or lunch detention or things like that? So you have to think about, at the very beginning, what might happen here. If it's something that you think is going to be an 80-day expulsion, we're going to get into the world of a change of placement. And the reason that this is the third question is asking this question is really important, because what we intend to do or what might happen is going to drive what process is required. If we get into anything that looks like, sounds like, seems like a change of placement, that is the trigger for a lot of things. Okay. So knowing when there is a disciplinary change of placement is critical so that you can figure out what comes next. So let's start with things that are low level. An in-school suspension. Okay. An in-school suspension is not going to count against your days if the student has the opportunity to progress in their general ed curriculum, if they continue to receive all of their IEP services, all of their specialized instruction, the supports, the accommodation, and the students continues to participate with non-disabled students to the same extent as they would if they had not been put in ISS, meaning that they're not segregated in, like, this is the ISS for disabled students and this is the ISS for non-disabled students. So that's segregation. So if a student continues to receive their services, they progress with the general curriculum, it's not going to be considered a day of removal. A bus suspension will be a day of removal only if transportation is provided as a related service. So if transportation is a related service in the student's IEP, a disciplinary removal from the bus would be a removal from a related service, and it would be treated as a removal from school. Like, think about that in any other context. A disciplinary removal from your speech therapy services, which is a related service, would be a removal from your IEP service. So a bus suspension is going to count if transportation is a related service. Now, if transportation is not a related service on the student's IEP and they get kicked off the bus and the parent can't get them to school, that doesn't make it a disciplinary removal. So it really depends on whether transportation is a related service on the IEP. Other disciplinary consequences like study carrels or detentions, times out, that they're not going to trigger those IDEA procedural protections. So let's think about then, as we move up, we've talked about in-school no suspension, no removal, in-school suspension, bus suspension. Now let's think about those short-term removals, those less than 10 days. So as I mentioned earlier, the IDEA authorizes school officials to remove students for 10 cumulative school days in a school year without providing special education services, as long as regular ed students don't receive educational services during that time period. So there needs to be some equity with students with disabilities and students not, students who are not identified as students with disabilities. Now remember those model policies, because those model policies, if you were to adopt those and to follow the aspirational language in those relative to the 10 days or less, you are likely going to be treating students with disabilities different than non-disabled students. So there goes your equity argument. So when we think about removal in a school day, what is a removal? Well, the IDEA regulations define a removal as any part day, any day or any part of a day that students are in attendance at school. Well, a school day is any day that students are in attendance, and that portions of a school day that the student has been suspended may be considered a removal when determining whether there's a pattern. So sometimes I get a call like, well, we removed them for 2 class periods. Does that count against our days? I take the conservative approach and say, yes, it does. So you have to have somebody counting days, because if you have not adopted that aspirational language in the model policies, you can go up to 10 days without provision of educational services. But once you hit that 10th day, you've got to start providing services. So day 11, I call these day 11 services. On the 11th day, student is entitled to receive services. Okay? Now, that doesn't mean that on the 11th day that there's been a disciplinary change of placement. So those are 2 different concepts. Day 11, everybody gets services. But we don't need to do a manifestation review until we get to what is considered a disciplinary change of placement. Okay? And disciplinary change of placement is important not only for the manifestation review, but it also is very important because when you get into a disciplinary change of placement, it changes how those day 11 services are determined. Okay, so let's say you've got a series of short-term removals. I've got 3 days, I've got 4 days, and I've got another 5 days. Okay, we've added up more than 11, right? 3, 4, yeah. So I've got 3, 4, and 6. Okay, so we're at 13 days, and if those are short-term removals that don't constitute a change of placement, who determines the day 11 services is one of the child's teachers, the district in consultation with one of the child's teachers. So the district can determine that that student is getting, a certain amount of instruction, or they're attending an alternative school, that the district can determine through that consultation. But once we go over into a change of placement, you actually have to have a full IEP team determine the services that are provided. So, what constitutes a disciplinary change in placement? This is the key to understanding. A disciplinary change of placement is considered to be more than 10 in a row. So 11 days in a row. Okay. We're turning it up to 11. So any expulsion, because any expulsion in Ohio is going to be 10 days, more than 10 days. So if we've got 11 in a row, we've got a change in placement. That is easy. And once we have a change of placement, we're going to be doing a manifestation review, and the IEP team is going to determine the services. Okay. So it's easy 11 in a row. What gets tricky and what trips up districts sometimes is more than, so 11 or more than 10. And there's a series of removals that constitute a pattern. So know that you can have 3 days and then 4 days and then 6 days. So then we've got 13 days. And if all of those 13 days, the child's behavior is substantially similar in those 13 days, the total amount of time occurred between September and October. So we've got 13 days in that short time period. Then we're going to be thinking that this may be a pattern. And if it's a pattern, then it constitutes a change of placement. And remember, when we cross that line for change of placement, that's when we have to do the manifestation review. You do not need to do a manifestation review. I'm going to have another dramatic pause here. For anything under 11. Let that sink in. There's no requirement to conduct a manifestation review if you are not at 11. And it's not that maybe they might go over 11. That's not the trigger. The trigger is they have been subject to a series of removals that constitute a change of placement. It's not that it's been recommended. It's not that it's been proposed. It's that it's actually happened. So 11 triggers, 11, that's a pattern, triggers the manifestation review. I know many districts that do the manifestation review before they even have to. It's not legally required. And so just, I know it's a challenge to convene team meetings and get everybody around the table. If you don't have to do it, consider whether that should continue to be your process. So you might have those 13 days. It could be 4 days. It could be 4 days because the student was insubordinate to the teacher. And then it could be 3 days because the student skipped a Saturday school. I don't know. And then it could be 6 days because the student was caught with a vape. Okay. So we've got 13 days, but those behaviors aren't substantially similar. I wouldn't consider that to be a pattern, especially if it's drawn out for the entirety of a school year. So now we could have 13 days. If it's not a pattern and it's not a change of placement, you do not have to do a manifestation review. And you wouldn't have to have the IEP team determine what services are necessary on day 11. When it is a pattern, or it is a change of placement, the IEP team has to determine what interim alternative educational services are provided, what services are provided on day 11. Now, if you are a district that has a one-size-fits-all approach, where the same services are provided for every kid, that might be problematic because the IEP team, I mean, if you just had to do 1 hour a day of home instruction for every day over 10 for students whose placement has been changed for discipline, why would the IDEA say that you have to convene an IEP team meeting to determine those services? It wouldn't. So you can't use a formula to determine what is necessary. It might be appropriate that the student gets 1 hour a day of home instruction, or that might not be appropriate for the student. So the IEP team has to determine what services are required on day 11. All right, let's talk about the manifestation review. So we know that the manifestation review is only required once you get to a disciplinary change of placement. When is that required? The law says, and this is in your materials, the manifestation determination must take place within 10 school days of any decision to change the placement of a child with a disability. So the decision to change placement could be when the superintendent says you are expelled. So superintendent says you are expelled. The district then has 10 school days to conduct the manifestation determination. Now, I know that many school districts do the manifestation determination before. Just know that it is not legally required. Okay. All right, who conducts the manifestation determination? It is relevant members of the IEP team. Who determines relevance? District and parent. And what do they do during that process? They consider all the information in the child's file. They look at the relationship between the behavior and the disability, and they determine whether the misconduct was caused by, or did it have a direct and substantial relationship to the child's disability, or was it caused by the district's failure to implement the IEP or the behavior plan, that would be incorporated. So the team engages in a discussion about that, comes to a conclusion. If there's disagreement about that conclusion, the district issues prior written notice. And if the parent disagrees with that, the parent can avail themselves of any of the procedural requirements or the procedural safeguards that I'm going to talk about after we have a break, which would be, administrative review, due process complaints, things like that. So if the conduct is determined to be a manifestation of the disability, the district conducts a functional behavioral assessment. This comes into play where it's necessary, and implements a behavior plan. If the behavior plan is already in place, you've got to review that behavior plan and see if there's any adjustments that are necessary. And if the behavior is a manifestation of the child's disability, the student goes back to school in their setting. So there isn't a set of circumstances where we say, hey, it's a manifestation of the child's disability, but we're going to put them on home instruction anyway over the parent's objection. That's not a thing. Okay. Student gets returned to the school setting. Now, if the district believes that maintaining the student in their placement is likely to result in injury to that child or others, the district can file due process or seek an injunction from court to remove them on dangerousness. Okay. So there is also an exception to this. So, and I will talk about this when we get to our fourth question. But if the student engages in behavior that involves drugs, weapons, or commission of serious bodily injury, so they've caused serious bodily injury, there is an exception to this. So hold on that. So we talked about if the behavior wasn't a manifestation or was a manifestation of the child's disability, unless it was drugs, weapons, or serious bodily injury, student goes back to school. If the conduct is not a manifestation of the child's disability, student can be removed just like any other student, but day 11 services always apply. You're going to get those day 11 services. Okay. All right. Last question is, was there some sort of special circumstance involving safety? So this is drugs, weapons, and serious bodily injury. So if a student, let's say I always use this example, but I'm going to use it again. Student gets on the bus. Student we know is identified as emotionally disturbed. They have paranoid delusions. We know that it is part of their disability. Student gets on the bus. They pull out a knife from their backpack. They pull the knife on the bus driver and they say to the bus driver, you are not going to abduct me. And I'm going to cut you. There's some sort of threat because the student believes that the bus driver, who the student has known for the entire school year, is a kidnapper. Okay, so they're having these delusions. So the student has carried a weapon onto the bus. That knife is a big one. It's a kitchen knife. And we would say, yeah, that behavior is a manifestation of their disability. But because this is a special circumstance involving safety, we are going to allow the school district to unilaterally remove that student to an interim alternative education setting for up to 45 school days. So if you have that situation where it is a weapon, drugs, or the student has engaged in conduct that causes, not that it's potential to cause, but that has caused serious bodily injury, those are those special circumstances involving safety. Now, in your materials, there's a lot of cases about what constitutes a weapon, what constitutes drugs, what constitutes serious bodily injury. I would direct you to the paragraphs that talk about serious bodily injury that is really serious. It's not the things that you would typically run across in school, like cuts, abrasions, burns, pain, illness, things like that. It's like somebody's gone to the hospital, somebody might die, somebody might lose the function of their eyesight. It's really serious stuff. I hope you never see any of it. But not so serious bodily injury is not going to qualify. A threat of bodily injury is not going to qualify. So just take a look at the cases that interpret serious bodily injury and just exercise caution there. So, as I mentioned, if the student engages in conduct that involves this safety issue, and that safety related conduct is a manifestation of their disability, the student can be removed for up to 45 days. Okay, and you would put them in an interim alternative educational setting. The parent has a right to appeal, and we're going to talk about appeal rights after we take a short break. But know that if there is an appeal about discipline, the procedures are on an expedited fast track, meaning the procedures are going to happen where there's going to be a hearing within 20 school days, and things are going to move really, really fast. So whenever there's a challenge about discipline, that is something that is uncomfortable. Let's just say that it's uncomfortable to go through because it really goes quite quickly, which is one of the reasons why my suggestion to you is if you don't have to do a manifestation review, don't create an issue about manifestation, because that leads to a fast track hearing. So that's just something to think about. I did also mention that even if the behavior is a manifestation of the disability, and even if you can't get them in an interim alternative setting for those 45 days, districts still have, and I think this might be the last slide, districts still have the ability to file a lawsuit or an action about some sort of discipline. They can have a hearing about discipline. So there's this thing called the Honig injunction, which allows a school district to go to court or to a due process hearing officer, one that's appointed by the state, to argue that maintaining the student's placement is substantially likely to injure that child or others. That is not something that is an immediate relief. It is not something where you can hold the student out while you're pursuing that, but it is something that is available to school districts. I've had a few situations where districts have taken that step because they truly believe that there was a danger that needed to be addressed through litigation. So, and similarly, so districts can file that, and then parents can appeal through all of the procedural safeguards that we'll talk about in the conflict resolution section. The last thing that I think is the slide is about when we're making referrals to judges and authorities. So know that you can report crimes. That might be something that needs to happen if there's a crime that's committed by a child with a disability, but also know that there is a requirement to inform law enforcement and others that the student may be a child with a disability. But you have to do that either with consent from the parent or by getting a subpoena from law enforcement. So just know that. All right. Is that our last slide for this? Okay, so now we have some recommended compliance strategies. So our first strategy is we want to make sure we proactively address behavior, right? So that's one thing that we know we need to do. We need to train employees on our behavior management techniques, crisis intervention, disciplinary procedures. We need to monitor our referrals and document parental refusal of services. We need to consider the use of disciplinary consequences that don't get us to day 11 or day 10. But when we have those disciplinary referrals, let's closely monitor them. And our next one is making sure that we're doing the manifestation review in a way that's consistent with law, maybe not doing them when we don't have to do them, because it creates some legal issues. Next one is consult with those who have expertise with behavior. If you're going to have a manifestation review, I'd like to have somebody at the table who has some understanding. If the student has mental health needs, how does that mental health need present? I mean, I have my copy of the Diagnostic Statistical Manual of Mental Health Disorders. Do you have somebody at the table who understands the diagnoses for that particular student? Do you have somebody who can speak to how that diagnosis presents in that particular student? If not, how are you doing any type of thoughtful analysis of the relationship between the behavior and the conduct? Number 8 is ensure that your services that you're providing on day 11 are individualized. There isn't a one-size-fits-all approach. If you have a standard that everybody gets an hour a day, consider, is that individualized? Number 9 is making sure that everybody who works with the student, including those individuals, bus drivers, coaches, things like that, they understand the behavioral intervention strategies that are necessary for that particular student to help them learn how to manage their behavior. And I think we take it up to 11. So provide positive behavioral interventions and services. So your behavior intervention plan shouldn't be a series of consequences. Shouldn't be that if the student does this, they will be removed. That's not a behavior plan. That's a punishment plan. And so make sure that your behavioral intervention strategies and supports are positive, because that's a legal requirement. And then make sure that everything I talked about at the very beginning, meaning the notices, the due process procedures, that all applies to students with disabilities. You have to have equity in the procedures that you're following. All right. I'm going to pause. Oh, we'll skip over that. So let's go. And I just want to make sure, let's see, do we have any questions before we take a break?
Nope, not at this time.
Okay. Oh, I see people popping off. Hello, Sheila. Hello, everybody. If there are no questions, then what we're going to do, it's 10:08. Give everybody a 15-minute break to answer calls and return emails. We'll come back at 10:23. Did I do the math right? Yeah, 10:23. Oh, we have a question? All right.
No, I don't think so.
Oh, yeah, that's the old question. All right, 10:23. We'll see you back. We're back. If there's any chats, I need to. All right. Chats are just talking about the break. All right. So today, the next part of this is kind of the compressed version of Dispute Resolution 101. Because you're going to be in a dispute. I'm just telling you, well, maybe you're not. But the reality is nobody's calling the lawyers when there's not a dispute. So my worldview of things that are occurring in schools is that there's just dispute all the time, because nobody calls me and then, oh, we just had this IEP team meeting and it went great. And everybody was on the same page, and I don't get those calls. So I kind of have a skewed perspective of what happens in special ed, because that's the only thing I'm exposed to is disputes. So based on that experience, and I've been doing this for 28 years, I think. Yeah. Based on that, I have some perspective on those things that are most likely to result in costly disputes. So we're going to talk about that. I'm going to talk about what options there are for resolving disputes within the process. And we're going to be thinking about strategies for you as you manage this process. So first thing is, I believe our first slide is, what are the top 10 things that issues that come up. So the first thing is not recognizing what I talked about before we took the break, which is this discrimination piece. When there is a concern about disability discrimination, it's a big deal. Okay. Why is it a big deal? Well, whenever you hear something that looks like, sounds like, seems like civil rights and being treated differently because of my race, my gender, my disability status, my national origin, again, that kicks off a whole set of procedures that are that fall under the governance of the Office for Civil Rights, that fall under a different part of your board's policy. So there are different standards, there are different procedures, there's likely different administrators that are responsible. So it's something that people can mess up pretty easily and not recognize. And then when there is something that is filed in court, any type of civil rights litigation creates the potential that there are damages claims, big money claims, attorney fee claims. It's just, let's just close your eyes and look at and see big dollar signs. So that's an issue because it can result in significant liability. And when districts don't follow those different standards, those different procedures, they don't involve the different administrators that are identified under their board policies, that's when courts come in and second guess the decision-making process because you haven't followed your procedure. Okay. Second issue that can result in costly conflict is failing to understand your obligations regarding non-academic and extracurricular activities. Again, another type of civil rights issue. Now, it was back in 2013 when the U.S. Department of Education issued a guidance document. It was a Dear Colleague letter that informed schools and colleges about the requirement to provide athletic opportunities for students with disabilities. And that was done in response to a report from 2010 that concluded that students with disabilities weren't being offered an equal opportunity to participate in extracurricular activities and athletics at the elementary and secondary school level. So just know that was on the radar, which is the reason why they issued this guidance document. If you haven't seen the guidance document, I'd get your hands on it. It's referenced in the materials that I sent. And if your coaches and your athletic directors and your principals haven't seen this guidance document, that might be a good training to have because it articulates the lengths that school districts must go to ensure that students with disabilities are not discriminated against and they're not treated differently based on their disability status in their access and participation in non-academics and extracurricular activities. So don't use, when you have to go through the IEP process and you have to get to that section about non-academics and extracurricular activities, that's not a throwaway section. That's not all right, they have the same opportunities as everybody else, let's move on. The question is, do they need services and supports so that they do have an equal opportunity to participate? So that's something that I see often is missed. And our next one is, let's see, not accessing supports from experts. Just get a second opinion. Like your team might be like fully entrenched, like this is the way it has to be. This is not a necessary service that's being requested. Let's say maybe the regular ed teacher is requesting it, or maybe the parent is requesting it. Sometimes people get kind of the blinders on and a second opinion, whether it's an internal expert, maybe you have a behavior consultant within your district. Maybe you have a literacy specialist within your district. Maybe you have a school site with a particular area of expertise. You can train your internal experts to help provide guidance for the team, because if the parent is in disagreement, they're going to get a second opinion. And you want to make pretty darn sure that your opinion or the decisions that are made by the team are supported by data, are supported by assessments, are supported by work samples. not just like, I know it when I see it, the kid is going to be able to read. Getting a second opinion could also include communicating and coordinating with outside experts who are working with the child. So maybe the child's working with a private speech therapist or a tutor. Don't bristle when the parent is saying, well, I'd like to get a independent evaluation. You have to respond to that in a way that is consistent with your policy. So responding to requests for independent evaluation, you probably have a procedure that articulates what you will or will not do in the context of an independent evaluation. And sometimes getting an independent evaluation is the preview that you might need before you get litigation. So sometimes I think that that's just not necessarily cheap, but it's an easy way to see what's coming should there be litigation down the road. And then your experts could also include, folks like, the SOS team at the SST, or maybe it's the ESC, right? I can't remember who has the SST, who has the SOS team. Erin, is it the SST or the ESC?
The ESC does.
Okay, so I was wrong. So, the SOS team here in Central Ohio is a great resource that, and different ESCs might have different resources. So it doesn't necessarily need to be somebody outside the education community, but it could be. You might, access your SST or your ESC consultants so that, you can get a kind of a second opinion. You might call legal counsel, you might call neighboring districts, but just think about getting a second opinion so that you have some basis to understand if we're just kind of, all in the same mindset and not recognizing that there might be some vulnerabilities to that position. Our next issue that I think creates some legal challenges is kind of the out of sight, out of mind problem, where you have students who are not coming to school because they're either truant, they have medical needs, they have mental health needs, and that maybe we're not engaging with the child find process and not considering their eligibility. And maybe that they're not coming to school because of a disability related needs. You might be thinking, well, they're not coming to school, but they're doing fine. Like they're getting okay grades and they're moving on. But educational performance is much more than just academic achievement. And then similarly under 504, don't forget that those students who have health conditions that don't require special education, that those individuals may be students protected under Section 504. And protection under Section 504, and I know we had a whole session on Section 504, so I'm not going to get into it here, but remember that being protected under Section 504 does not necessarily mean that you have a 504 plan. You might have 504 protections, meaning that you can't be kicked off the basketball team because of your disability, not allowed to go on the field trip to Washington, D.C. because the district doesn't have a nurse to go and administer diabetes. Like those are protections from discrimination. Those are protections to ensure access to the district's programs. And those protections exist regardless of whether or not that student needs any type of accommodation. So you might have students who are protected under Section 504 from discrimination, but they might not need any affirmative service from the district. And those students would still be students who would receive procedural safeguards under Section 504, have notice of their rights under Section 504, and be able to file complaints internal to the district and go to the U.S. Department of Education's Office for Civil Rights if they believe that there has been some sort of discrimination. Our next issue is making determinations based on things other than the needs of the child. So this is when there might be somebody engaged in predetermination, making a decision based on administrative convenience, or what days the speech therapist is actually in the building. You can prepare. So preparation is not predetermination, but you have to avoid coming in and having it all kind of wrapped up in a bow and like, this is how it's going to be. Because predetermination basically means that the parent didn't have a meaningful opportunity to participate. So you have to make sure that you document that you gave the parent a meaningful opportunity to participate. Doesn't mean you have to agree with what the parent asked for, but you have to consider every request. You have to document the parent's participation. You have to respond appropriately, meaning that the decisions that you make show that it's based on the team, it's based on the data, it's based on the student needs, and it's based on the standard of FAPE. So it's not just, would it be nice? Like, it would be nice if I had an aide. Like, I would love an aide, one-on-one aide. It would be nice. It would benefit me. Do I need it? That's the different standard. So the FAPE standard is a standard of necessity. The student requires, student requires this in order to receive a free and appropriate public education. Not that it's going to be nice, that it is necessary. So you're considering all of the things that are requested, including a request for private anything. The parent comes in and says, I've been exploring this private, insert anything, private provider, private therapy, private residential treatment facility, private tutoring. What does that mean? It means that the parent has lost faith in the services or lost confidence in the services that are provided by the district. So that should be a red flag for you. If the parent says, I'm exploring, or I've obtained, or I would like you to pay for private anything, you need to respond appropriately, which is those things I mentioned. We're going to convene a team meeting. We're going to look at data. We're going to consider the individual student's need. Do they require that for a free and appropriate public education? How do you do that? Well, you've got to gather information about the private program. You've got to request a release. You should offer to visit that program. You should offer to schedule a meeting with the private tutor or the therapist. You should offer to conduct observations there. Offering, I mean, parent might not allow you, but I would be documenting your attempts to gather information about the private program so that the team can consider it. And then you critically evaluate. I mean, is the student engaging in that private program? Let's look at the progress data. Do you need to conduct an evaluation? And all of that needs to be done through the team process. The next one that I want to highlight is, it takes some more tea, ignoring mental health issues and behavioral issues. So just because a student is getting good grades doesn't mean that there are no issues for child find. Then the unfortunate communication errors. So just be really careful what you put in email correspondence. Use caution with reply to all. Use caution when you're venting your frustrations to your colleagues about a particular meeting that didn't go well or whatever it is, because many times that the email correspondence might be an educational record. And I might need to take a break from my inhaler. Might be an educational record. And if it's not an educational record that the parent has access to, it might be a public record. So just train your staff that when they are rushing to reply, or they're replying to all, or they're using the email as a substitute for prior written notice, or they're super overwhelmed because somebody is emailing all the time and they're not responding to them. Those create problems. All right. Failing to conduct effective IEP meetings. This is all of the things that you learn in terms of facilitation, making sure that you remain professional, making sure that you set out clear expectations for the meeting, meaning, is there going to be an agenda? Is there going to be timelines? I mean, the one thing that you can do right now, like today, is make sure that everybody is articulating the beginning and the ending time for IEP meetings. You could do this right now. You could avoid a lot of problems when parents are walking in there and they're expecting the IEP meeting to go for, I don't know, 2 hours because this is the most important thing in my calendar today. And you've only allotted 45 minutes. And people just start getting up. And, there isn't a shared understanding of the beginning time and the ending time. So communicate those expectations. Communicate what is on the agenda. Ask for agenda items in advance so that you can understand who needs to be there, what issues that the parent wants to bring up, and that you can allot the appropriate amount of meeting time for that conversation. And then make sure that you prepare information to come to the meeting, to have at the meeting, so that you can back up what you're saying with data. So summaries of progress, charts, work samples, visual aids, critically important, so that you can talk about how you came to a decision, because you came to the decision as a team based on data, looking at the child's individual needs for the provision of a free and appropriate public education. If you don't have that data conversation, you're missing that really important element. Failing to ensure that non-special ed administrators, so this is your building principals, athletic directors, transportation supervisors, that they are informed about and know that there may be some special ed implications in the work that they do. So providing training on compliance, making sure you know how that training information is disseminated to staff, making sure they're kept updated on new requirements, make sure they know how to collect data, how to document, how to facilitate difficult meetings, how to try to resolve conflict, and then providing them with access to reference material. So maybe the information that I've shared, like I referenced that guidance document on extracurricular activities and athletics, making sure they have the reference materials that they need. And then making sure they know who to call, who they pick up the phone, they're going to do a phone a friend, who are they calling when they need support? Who can provide assistance? Is it central office administration? Is it internal experts? Is it external to the district? Consultants and attorneys. And then, what is the process for accessing those resources? Can anybody call? Let's see, on our next slide, I wanted to just talk about, when we have a need for legal support. I know that when you need a lawyer in a special education matter, most of the time things aren't good. Like I said earlier, you're not calling the lawyer to talk about the meeting that went right. You're calling because there's a conflict, you need help to fix it, the situation's uncomfortable, and you want somebody to help make things better. Now, my experience, again, 28 years, I think special ed people are just genetically wired to avoid conflict. And when they have to deal with it, it can be painful. I see that. I don't have that genetic wiring. That's why I picked being a lawyer, because that conflict is the business. But I understand that, not everybody is wired in the same way. So you need to understand that you do have some options for legal support. So, you may have your district's, appointed counsel. We work with many of the people who, I recognize on the call today, but that's not the only option for you. There's attorneys that are in private practice. There's also association counsel, the state school board association. There's administrator associations, like BASA has counsel. You might have an in-house counsel. I know many big urban schools have in-house counsel. There are some people who have access to the county prosecutor to provide support, and the county prosecutor may or may not know about special education. You also might have access to counsel if there is a complaint filed or a due process hearing request filed. Your insurance company might appoint counsel, and you might get coverage for your special education claims. If that is not something that you are discussing with your board appointed counsel, you should be. Because you need to evaluate the cost and the benefit for accessing your insurance coverage to provide coverage for those special education legal costs. And you're going to ask, and there's questions in the handout, what is the scope of your coverage? Does it cover the cost of the defense? Does it cover the cost of a hearing officer? What will be the impact on your premiums? Who will you appoint to assist the school district? Are you going to appoint somebody who has experience with special ed? Can you use your current general counsel for that appointment? If they're pay a particular amount towards your lawyer, is that an option for the district to cover the remainder of the fees? Understand those obligations, and your obligation at the first is to notify your insurance carrier as soon as possible, so you can determine whether or not you have coverage. Sometimes if you're not, if you don't provide that notice in advance, or not in advance, like as soon as the insurance company might say, we're not going to cover this because you didn't provide us with notice. Now, I see that there was a question, so let me open up the chat. It's in a different part of my screen.
If a parent has agreed to the gen ed leaving a meeting after answering questions and sharing all of their input, and it is documented in the PRO1, does an excusal form still need to be filled out because they are not staying for the entire meeting?
Yes. Written excusal is required. So that excusal form documents the parent's written agreement to excuse our general ed teacher from all or part of the meeting. And actually, I am presenting a national conference on the general ed teacher, so I think I just prepared my material, so I'm confident in that answer. Yes, the district has to get a written agreement to excuse that person, and the person, if the person leaves, I would get that excusal, because on your IEP form it says, this person was excused for all or part of the meeting, and so you just would need to get that written verification. All right, hopefully that is clear. What's our next slide? Our next slide is, if you are going with looking for counsel, make sure that you think about, if it's the county prosecutor and you have access to the county prosecutor, just ask, do you have experience with special ed? You wouldn't buy a house without first having it inspected. You wouldn't buy a car typically without, knowing how it drives. You'd probably want to do your due diligence. So, ask folks in the education community for recommendations. This also applies when you're getting insurance panel appointed. The most important factor that the school should consider when selecting counsel, when you have a choice, is the experience of that attorney in that substantive area. And special ed is one of those areas that it's hard to dabble in. So not just expertise, is the attorney efficient? Do they have a reputation for making simple things complex? Some attorneys can do that. Or making things a dispute, particularly acrimonious, conflict, you might want that. You might want to take no prisoners type of lawyer that might be what you need in a particular situation. Sometimes that frustrates the collaborative process that's intended in special ed. It could have the potential to drag out the conflict and increase your legal fees. But, that might be a situation where there might be a situation where you want somebody in that. I devote the majority of my practice to special ed, and you know what? Probably just 1/3 of it is legal. That 1/3 of it is, what do the laws and the cases say about delivering services? 1/3 of it is educational, like what are the scientifically based methods for teaching reading? Like, this is why I have my own copy of the DSM. Like, what how to navigate things that aren't legal. New methodologies, things like that. I do a lot of research there. And then I think, so that's 1/3 of legal, 1/3 is educational. And I think the last third is relational, like how to successfully resolve disputes, how to facilitate team meetings, how to communicate in difficult information. So that's just how I think of my approach, but there are others on my team who have different mixes. And there's other colleagues that I know in the field. So you might need somebody in a particular dispute with like really high relational skills to try to resolve disputes and try to get everybody to calm down and not go the litigation route. But then in another situation, you might need somebody who's like, okay, we're going to go to hearing and we're preparing. So I would just suggest evaluating what you might need in any particular moment, based on expertise and then their additional skills, because a significant part of the job involves those non-legal legal issues. So you also need to evaluate the intangibles. So, do you have somebody who is strategic and prepared? Are they responsive? Are they somebody that you can kind of rely on when you're in the trenches? You also need to understand the fee structure. For most private attorneys, the most common fee structure is the hourly rate. That it sometimes depends on the attorney's expertise and the amount that's typically charged for those services. How are you going to be charged? Is it a flat fee? Is it as you're making decisions, just ask those kind of questions. Consider that if somebody can answer the question in 1 minute, and somebody who doesn't have a lot of expertise in that area has to research it, it could actually come out in a how you might not think it would come out. Like somebody has a higher hourly rate, but they can answer the question in a minute, versus somebody who has to do 2 hours of research that might just cost more. So those are things to evaluate. I'm not going to belabor this process. It's just that you need to understand those costs if you have a choice. All right, next slide is when you're working with the lawyers, and this is another thing that I'm speaking at the case conference, and my topic is going to be help me help you, kind of how to reduce costs for legal services. So one of the things that is helpful is knowing, like, what is the best way to reach you. I use a Calendly link. People know that they can just put time on my calendar. But often I have a lot of folks that I talk to late at night, because it's the time that you guys are digging into your emails. It's sometimes the time that I'm digging into my emails. It's not when I'm presenting or in IEP meetings or things like that. And so sometimes that's preferable for people. Ask, what is your preference? I like to ask, do you want this in writing? Do you want this over the phone? Do you want me to give you my gut reaction? Do you want something that is backed up by a case law? But you, as the school district, need to set that expectation. Is your preference a telephone conference or a face-to-face meeting? What's the desired work product? Is it do you want to draft the prior written notice and then I can lawyer it up? That's usually the least expensive option. Do you want me to give you a sample document that can be used for your expulsion hearing or your resolution session, things like that? But to effectively communicate what your needs are, effectively communicate what the access is, and understand the ethics that the school district's lawyer is the Board of Education's attorney. It is not the person who's representing any individual. So when you need support, this is just to say, you can save money in legal fees if you are clear about your expectations, collaborate in a way that creates some efficiencies, and then focus on prevention. I mean, I typically tell districts that it takes, and I use this analogy a lot, it takes less time for me to explain to you how to navigate around the minefield than to have you just go out there on your own and step on it, and then I have to put the pieces back together once there's been that kind of misstep. So having that kind of clarity and understanding prevention does go a long way. All right, our next slide is, I said most of these things. Okay. Make sure you notify your attorney if there's potential legal claims or threatened legal claims as soon as possible. That gives you an opportunity to navigate around the minefield. If something has happened, and sometimes the special ed director will call and say, I just got this due process complaint notice. It's been sitting on the superintendent's desk for a week. It took me a few more days to get me, to get it to me through interdistrict mail, things like that. You've burned a lot of days. Like when there is a complaint that is filed, a lot of things occur and are timed from the day the district gets the complaint. the day that it lands in the inbox to whoever at the district. It might not have gotten to you for a week and a half, but sometimes you have to respond in a week and a half. Sometimes you have to respond within 5 days. Sometimes you have to respond. Sometimes hearing officers will say, send you a letter and saying, we're having a phone conference tomorrow. So just train the folks around you that if it looks like, sounds like, seems like something that is legal in nature, make sure it gets to you if you are the administrator, and that you get support as soon as possible, because so many timelines begin to run on the day that the school district receives the notice. So it's helpful to have somebody stamp it so that we know when it was received. Prepare in advance for the calls with your attorney or anybody else that you're accessing support. I'm a person, and I'm just one person. There's many lawyers you could choose, but I'm a person who asks a lot of questions because I want to know all of the facts and just have that stuff available. Currently on my Calendly, some people can type in like, what do they want to talk about? And so that's helpful for me, because then I can orient myself to, okay, what is this phone conference is going to be about? And if there's something that I need to access in terms of legal standards or things like that, I can prepare. Don't be, when you have these conversations, don't be afraid to admit what has happened or ask questions that you think you should already know. There's just nothing worse than being in the middle of a due process hearing and having your client tell you an important fact that wasn't disclosed earlier, and it may have impacted the entire case and the strategy. So like, it's a safe space, even if you think you should already know something, or even if you think, gosh, I might have made a blunder, that's okay. I mean, that, not everybody can know everything. I don't know everything. And, it's a collaborative process. So asking critical questions in advance, like, did we implement the IEP? Did we follow the proper procedures? Can we prove that the student is making progress? How do we know that? Does the data support that? If we made a mistake, can we fix it? Like, that often goes a long, long way. Making sure that you tell whoever's supporting you, what is the other things that are going on here? Like, is there some political issue that's going on? Is there some relationship issue that's going on? Is the parent who is filing all of these complaints, are they just mad because their husband wasn't selected as the athletic director? Or what, is there something else? So that you can, give the context. And then think about what are you seeking? Like, you're asking for support, but what is the ultimate goal for the district? Because sometimes, I think I told you, like 1/3 of my job is legal. I can tell you what the legal answer is, but sometimes that's not the practical answer. And sometimes districts want to take a calculated risk because it's not practical, or there's political or community issues that might be relevant. There might be some internal dynamics and some employment issues that might affect the matter. So, explain that and make sure that, the folks that you're working with have that kind of information. Then you can use your attorney or, others. There's others who can do this for you. Consultants, you can request technical assistance from ODE or OCR, but, you should kind of assess the issues and think about, what can the district defend? What are the risks and potential rewards of taking a particular position or proceeding with a particular course of action? What are the likely costs, both long-term and short-term costs? What are the interests of everybody involved? What weaknesses have we found in the parties' positions? And if this matter proceeds to litigation, what are the strengths and weaknesses of the potential witnesses that we might want to put on the stand to testify? Might want to assess, like, what is the legal precedent that addresses the issues? What other issues might be raised during a legal challenge? Is there some sort of resolution that might be possible? And if so, who might participate in those resolution efforts? Do you need somebody with a fresh perspective? Things like that. So there are things that you can do to help reduce cost. I think that's on our next page, which is, providing records, organizing those records. Listen, I'm happy, and I have dug into boxes and boxes of records and try to figure out the details of a student's entire educational experience. That's not super efficient. I have, people in my office who do that. But if you organize the records, I cannot tell you how much time that will save you. I recently had an experience with a district, and it was one of the most well-organized. They sent me every single thing, and it was labeled like who wrote the record, because sometimes you get just like handwritten notes. You don't know who wrote the record. You don't know what the context. It was really just super well done. And I just kept saying to this district, oh my gosh, this is heaven. So, but it's heaven for me. It's also for you a lot more efficient. Identifying the records. I think it might be on the next slide. Yeah. So scheduling meetings and assisting with communication. So, if you want an outside BCBA to be at an IEP meeting, if you want a parent mentor to be at an IEP meeting, if you want your legal counsel to be at an IEP meeting, just schedule the IEP meeting with any person's calendar in mind. And then can you create a first draft of a document? If you want support with a prior written notice, can you put your notes in the prior written notice form and ask for support? That will save time. Providing access to school policies and electronic records. Oftentimes we get prior written notices on the required form. We can't modify those because they're static PDFs. So if you want, an electronic edit to that, just need to provide it in a different format. And then just minimize the amount of time your attorney has to spend on kind of the non-legal organizational stuff. Like I'm not, and Maya, who's on this call, can attest to the fact I'm not the most organized person, but I have people around me who's organized. But that's often that's very helpful. When I set myself up to organize something, I kind of do it to an extreme, which some people have commented about that, and including my colleagues who have seen my law school notebooks, which was like 6 different kinds of tabs and had to have it in color coded. So it's not that I'm not an organized person. It might be the fact that I get too much in the weeds from organization. So enough about me. All right, next slide. And be open when you have a conversation, be open to a second opinion. Keep track of the advice that you get. Just remember that someone who hasn't been living in the dispute for years, or someone who doesn't have to manage staff or answer to the Board of Education or respond to the parent demands, they might have a more distance and be able to provide a different perspective of the matter. Be open to a postmortem. So postmortem is something that we talk about like after the conclusion of the matter. I called this the coulda, shoulda, woulda meeting. During that meeting, let's look at what has happened and consider if there are things that could be put into place to prevent or minimize similar conflicts in the future. Keeping up with legal developments, if you have been participating in the ESELA program or other professional development programs, you're doing that, and you know that things are changing all of the time. Things are changing with a huge amount of speed. I just saw a notice yesterday that there was information that people can, or students can self-carry their seizure medication. I believe that's coming into, gosh, I can't remember it. I think it's April, maybe would be the time frame. So, there's legal developments that are happening all the time. And then ultimately, periodically evaluate the legal services that you're receiving. You're the consumer. If you're not satisfied with some aspect of the services, just speak up. And the reason you need to do that is what I'm going to talk about in the next slide. Like, special ed litigation is costly. Okay. Special education can be costly, and you want to make sure that it's costly not only in the amount that it costs, but just the emotional and energetic costs. For those of you who've been through very hot litigation or complaints, or parents who are have a lot of concerns, how much the toll that it can take on your staff. So we think about how litigation and conflict in special ed can be really costly from a financial standpoint, and then from a administrative standpoint, because when you're pulled away to respond to 56 complaints from a single parent, or some sort of litigation, it does take time away from other requirements of your job. I think I'm on the next slide. All right. So all here, I have said this before. I'll say it again. There was a song back in the day. I have gray hair, so it's back in the day, called 50 Ways to Leave Your Lover. Do you remember the song? Well, it's like there's 50 ways to complain about your school district. Not really 50, but it seems like there's a lot. So there's administrative review. That's the process under which the superintendent or their designee is going to review some action that was taken by the district. That's something that is under your policy. There is filing a complaint with the Ohio Department of Education and Workforce. That is we call a state complaint. There is the ability to file what's called a due process complaint, which is litigation. It's a hearing officer, it's a court reporter, it's briefs and lawyers and all kinds of things. You can file a complaint with the U.S. Department of Education's Office for Civil Rights. I don't know how many people are still employed there, but currently, and I don't know what their administrative priorities are going to be, if it's going to focus on special ed, but if you've been reading the news at all, you should know that the U.S. Department of Education's Office for Civil Rights might be a fraction of what it used to be in terms of personnel, given the changes that have occurred since January. People can file complaints for public records. People can file a complaint to the U.S. Department of Education's Family Compliance Office. I don't know if that is being reorganized or that staff are being reduced in that section. I mean, we are going like this a lot because we don't know. They can file a complaint for discrimination. I said that before. They feel that either their child has been experienced discrimination or they've experienced discrimination because they've advocated on behalf of their disabled child. There's a complaint under your board policy. There could be a bullying complaint. They can file an inquiry with the media. They can file a personnel complaint internally with the district. And then there can be litigation. And I remember I said anything that's civil rights, they can just go straight to court and deal with that. So when we think about litigation, you have to think about the expense. So there's, I think on the next slide, two types of expenses. We've got the cost of the result, meaning you file a complaint about disability discrimination and you're alleging that these are a bunch of damages. So that's the cost of the result. And then the transactional cost of the process. That would be the cost of court reporters, cost of legal fees, things like that. And so many times when we get into dispute resolution, you balance those cost considerations. You think about what will it take to win? What does it mean to win? And is there a different way to resolve the dispute? So when you're in a litigation, what costs come to the district? I think that might be on the next slide. So if you're in litigation and you are appointed there, an attorney is going to be appointed by your insurance carrier. If your insurance carrier covers those costs, what the attorney is going to do is typically consult with you. They will review records. They will conduct an investigation, maybe interviewing staff. We might prepare witnesses. There might be research. There's meetings that occur, and then there's oftentimes resolution efforts. And then once you get into litigation, there's drafting motions and other documents, and then advancing the case at the hearing. More days of hearing equal more costs. So that, that's why I always talk to districts about, if you're in litigation, you really want to consider having some insurance coverage. But there's some other costs that might not be covered by your insurance, which in due process, the district has to pay for the hearing officer fees. You might have to pay for expert witness fees. You might have to pay for, you will have to pay for the transcript and the court reporter fees. And if the parent prevails, the parent wins the due process, or they get something that the district had not offered, then the parent might be deemed the prevailing party, and they might be able to seek their attorney fees from the district. So, and then whoever is dissatisfied with the outcome of that case, there's going to be an appeal. Okay, and there are costs involved in that. All right, I think on our next slide is something I've already covered. We talked about the administrative costs, the relationship costs. I also want to talk about the cost of stay put. So stay put is something that when there is litigation that is filed, during the pendency of any type of litigation, like an administrative or judicial proceeding regarding a due process complaint, the child remains in their current educational placement. So what that means is can't remove during the pendency of any proceeding, the child can't be removed. Well, fun fact, some of these cases take years. Like the due process hearing could be a year process, and then there's an appeal to the state level review. And then if they go to appeal to court, that's a pretty long-term appeal. And so that stay put could be costly. What also could be costly is setting a precedent. Sometimes districts evaluate, these are kind of bad facts. Maybe we don't want to go to a hearing with these bad facts. If any of you know the name Perry Zerkel, so Perry, he's a friend of mine. He did he's a professor emeritus at Lehigh University. He holds the distinction of having the most times that the U.S. Department of Education issued a letter. It'll be like a dear colleague letter, but sometimes it'll say dear so-and-so, because this is the person who wrote in, and the guidance is dear so-and-so. So you will see if you ever did a search for special ed, like dear colleague letters, and you wrote letter to Zerkel, he's the person who has the most letters that were issued under his name. Fun fact about Perry. Well, anyway, he does a lot of trainings. You might have seen him present. He actually did a study, well, maybe it was like 4 or 5 years ago. And the study was kind of an empirical assessment of who prevails in a due process hearing. And the study showed that the majority of the time in certain sectors of categories of cases, districts prevail. And kind of the conclusion was, I don't think it was a conclusion. I think what the takeaway could be from that study was that the cards are stacked in favor of districts. So Perry and I had a long conversation about this, because my reaction to that was, hey, districts only take cases typically to due process when the facts are good. The majority of the cases are usually, if they're bad facts where the parent might prevail, or there's some other issue, most of the cases are actually settled. So it's a very small subset of cases, at least in Ohio, that actually go to hearing. And it does make sense that of those very small amount, there's a large amount that is filed and a very small amount that actually go to a hearing or decision. And it makes some sense that of those cases, it's where the district feels really strongly that they have an argument. So take that for what you might consider, because just looking at the decisions and did so-and-so prevail or so-and-so prevailed doesn't really tell the whole story. All right, I see we have a question. As we are nearing the end of our session, we'd like to, oh, thank you. Okay. It's the survey. Sorry. All right. Well, another way to reduce cost is by preventing and reducing conflict. I think that's our next slide. So making sure that we have individuals who understand the applicable laws and procedures, they understand what they need to do, they don't put their foot in their mouth, they don't say something that's going to get the district in trouble, and they understand, what's required, what the options are, what are the community resources, and they're able to detect those early warning signs of conflict. So any type of communication change, like in the mode and the tone and the frequency, you might see somebody, and I don't know if everybody has the book Wright's Law, that there's like a book that Peter Wright wrote, and it talks about, ways that you can influence your school district, and you tell the story of your child, and you just kind of have this monologue where you put up a picture of the child in the IEP team meeting. You bring snacks because people can't disagree with you when they're eating your snacks, and that you tell the story. And then you write this letter and you copy the Board of Education. And it's just, it's kind of a play-by-play. If you know that is the play-by-play, that kind of tells you that there's an early warning sign of potential conflict. When somebody wants to come in and record the meetings, that makes people very nervous. When somebody comes in and asks for copies of all of their child's educational record, that's typically so that they can share that with an attorney or advocate. When there's complaints about personnel, they don't like this teacher, I don't like this principal, things like that. The district has discretion to determine what staff will work with a child. And that's an administrative decision, but know that a negative relationship, could create conflict. Of course, including advocates or attorneys in meetings, that's red flag. These might be in the next slide. Let's say requests for private placement. It's not okay. Services or consultation and appeals. So those are things that if you can recognize the early warning signs of conflict and try to resolve that conflict at the earliest opportunity, you will save money. Strategies for working with the board and district leadership. Just know who you're dealing with. Does your superintendent have special ed background? Do they need to be brought into the conversation early? What level of detail does your superintendent want to be provided with respect to the day-to-day management of special ed dispute? What information do they need to fully understand? What information do you need? Because if you are serving as the district representative, do you have the authority to commit district resources at an IEPT meeting, at a resolution session, things like that? And then know your board. What does the board need to be apprised of concerning legal challenges? Is it necessary to share confidential student information? Is that something that is necessary? Think about the confidentiality. And then know your community and the press. Parents may go to the media regarding special education disputes, and districts unfortunately are very limited in what they can say in response to inquiries. So if you have somebody who works with the media, if you have a communications person, make sure that there's a consistent way of responding to media inquiries, including any type of off-the-record statements. All right. I think our next thing is our conflict resolution options and strategies. So administrative complaints, that's where somebody can ask that the superintendent take a look at a dispute. That anybody can file a complaint. It could be a parent, it could be a disgruntled staff member. Once the complaint is filed, the district or the superintendent has actually, these are administrative complaints. I'm thinking of something else. So administrative review, let's take that. Not a state complaint. So administrative review is when the superintendent looks at something and either they or their designee conducts a hearing, which is really just like a meeting, and then comes out with a decision within 20 school days. So that's administrative review by the superintendent. That's internal to the district. An administrative complaint is when the parent files a complaint with the Ohio Department of Education and Workforce. Anybody can file that complaint. And once that complaint is filed, the department notifies the school district, they assign an investigator, and then they tell you through a letter of allegations what documents you need to provide. Now, typically, they request a pretty darn quick turnaround for those documents. And they are not super generous lately about extensions. So when you get the information, when you find out that a complaint has been filed, don't wait till the letter of allegations to start collecting records. You might want to start collecting records sooner than that. Now, ODE will allow for mediation if the parent and the district want to engage in mediation, but it's not required. Now, ODEW will ask you for the records, but I will tell you that what is very helpful is to not just send a bunch of records. Instead, when we write responses on behalf of districts, we prepare a narrative. We say, this is the story of Johnny Jones. This is how this is a student with a disability identified under this category. The team met on December 7th. Attached in Appendix A is a copy of the IEP. And you tell the story so that there is a kind of spot run version of what happened, because not everything that happened is documented in the records, because they're only asking for records. But then there's this catch-all that says, and any other information that you think would be helpful for OD to know. The department used to just call you up and say, hey, I'm from the Department of Education and I'd like to talk about this complaint. And usually during those meetings, they would ask you questions, which was their entirety of their investigation. And this was usually before they received the records. My understanding, and I have seen this happen, is that now ODE is getting the response and they are scheduling an interview for any follow-up questions. If that is not happening with you in your district, you need to ask for that. You need to say when ODE calls you, I would happy to conduct an interview, but not until after the district has responded, so that we can respond consistent, we can respond and point to the records or things like that. So your interview might be in person. It's typically by phone, but I would, prepare for that. I don't leave it to chance. Another thing that we typically advise for complaints responses is not only do a narrative, but if you've made a boo-boo, just say, we made a boo-boo, and this is how we're going to fix it. It is much better to offer your own version of corrective action than leave it to chance, because through the investigation, the department will determine whether the district complied with the applicable laws and will notify all of the parties in writing. And that letter of findings are going to summarize the facts and outline the corrective action. And usually, not always, but usually, if the district said, you know what, we made a boo-boo because we didn't, I'll use the example from earlier. We didn't get a written excusal when the regular education teacher left the IEP, even though the parent was good with that at the time, even though we wrote it in the prior written notice, we recognize that the law requires to get a written excusal. So here's what we've done to correct that. We've sent a notice to all of those who are responsible for running IEP meetings to remind them of the requirement to get the written excusal form filled out. So here's a copy of that memo that we distributed, and here's everybody who signed off that they received that memo. So that's kind of like you're offering the corrective action before they even get their hands on it. And that usually goes a long way. It goes a long way for your credibility that we noticed the boo-boo. We're not trying to sweep the boo-boo under the rug. And we're acknowledging that we needed some sort of corrective action. So those are things that I would recommend with respect to ODE complaints. And I have heard from the department that they do value when the districts are kind of just upfront about that. It makes their jobs a lot easier. So the timeline for this complaint process is that the department has 60 calendar days to complete that process. There are extensions that are permitted, but I'm just my view is that they're becoming a little bit more stingy with those extensions. For a complaint to be processed by ODEW, the issue or the complaint about conduct has to be within the last year before the complaint is filed. And so that's kind of their statute of limitations. All right, let's move on to due process procedures, which I think is next. Yep. Moving on to the next one. Due process procedures. This again, litigation and timing is everything. So we put in your appendix in your handout the department's quick reference for due process complaints. There's a flow chart of the procedures that are there in there. But what you need to know, because I don't have time to go into all of the details, but timing is everything. It is important to respond immediately upon receipt of a due process request, because there's several critical timelines for providing answers to the parents and selecting the hearing officer and challenging the sufficiency. Again, this is litigation. It's witnesses, direct examination, cross-examination. The due process, the statute of limitations is 2 years. So that's something that would typically, you're going to be talking about things that have occurred within the last 2 years, unless the parent can show that the district withheld information or that misrepresented that it solved the problem, or didn't send out prior written notices. Like there's some things that could open it up, and you might have a kid who's in 10th grade and we're talking about 3rd grade something. And that's very costly for districts when it's not contained within the last 2 years. One of the requirements for due process before you get into this expensive litigation is a resolution session. It is a required step in the process unless both parties consent to engaging in mediation. So you always should have an opportunity to try to resolve the issue before you get into this expensive litigation. And again, it may not be super expensive if you can get some insurance coverage for your legal fees. Okay, let's go to the next slide. All right, I'm going to skip over these things because this is outlined in that guidance document. So let's go beyond complaint responses. Let's skip over that. All right. If you get to a due process hearing, know that the party who files the due process bears the burden of proof. And sometimes when the parent files the due process, they have the burden of proving that what they're seeking through the due process hearing is necessary. So just know that that's, but if the district files the due process hearing, then the district bears the burden of proof. It's just a different legal standard. It's often the standard of who goes first. Okay, that's on our next slide. I mentioned this. Now, if the parent prevails, the district might be able to collect, the parent might be able to collect their attorney fees if they've become the prevailing party. Similarly, the district might be able to collect its attorney fees if it can show, if it is the prevailing party and can show that the complaint was frivolous, unreasonable, or without foundation, or filed for some sort of improper purpose. Okay, and that's a really hard standard, but I have had situations in IEP team meetings and others where the parent says, I'm just going to make your life a living hell. And because you didn't do this, I'm going to file complaints, and you are going to spend way more in litigation than you would if you just give me what you want. That's great language to put in a prior written notice, just saying. All right, we talked about stay put earlier, so I'm not going to talk about that again. What's on our next slide? One of the great things that you can use is facilitated IEPs for conflict resolution. It's free. Okay, it's free. We have a neutral facilitator who is appointed by ODE who comes in and helps with that facilitation. The outcome of a facilitated IEP meeting is an IEP. Similarly, mediation, which I think might be our next slide, mediation is also by a third party neutral, but the outcome of that is a settlement agreement, not necessarily an IEP meeting. Please, please, please consider the use of mediation and IEP facilitation. I have just had a tremendous amount of success getting to resolution through those options. If you don't know the mediators who are given to you as the panel, contact somebody at the SST, the ESC, contact your legal counsel. We know who these mediators are, and there just might be certain mediators that are better for certain situations. I mean, I know there's certain people that if there's an unrepresented parent, there are certain people who do better in that context. If it's something that's highly emotional, there are certain mediators that do better. If there's attorneys working on both sides, there are certain mediators that, that might be chosen. So know that there's some strategy and who to choose, because if you choose somebody who's just not well equipped to handle the situation, it's just going to be a waste of time. Mediation is confidential, so any exchanges that are made during that mediation is deemed confidential. So that might be another reason to choose mediation. All right, moving on. And then this is the administrative review that I mentioned. So I've already talked about that. That is a 20-day timeline for the superintendent or their designee to address a particular complaint from a parent. Last one, moving on more and more. And then the other, don't forget those other dispute resolution options. Like your IEP team meeting could be the best way to resolve a dispute. Okay. You can also resolve a dispute by proposing an evaluation and saying we just need more data before we can speak to something. like a new request for a new type of service. Last slide. And then other resources, as I mentioned, reach out to other resources, get an understanding of what's out there, what's information is accessible to parents. I often, try to get information from, what's being discussed at the parent advocacy seminars and things like that. What are the hot topics? You should know that as well. And other resources, I think. And last thing is me. All right. So any questions? Oh, I made it just to 11:30. Questions that I'm not able to see on my screen. Anything, Erin? Nothing.
No, I think we're good. Thank you so much.
All right. And then there was a note there to put something for the survey. So this year, if you didn't notice, we compressed some of the sessions. And this was kind of the experiment to see, the dispute resolution session and the discipline session were two separate sessions before. And we compressed, I think, eligibility and IEPs. We compressed those. So, how did it go? Did you like that? Would you prefer that it be separated out and that we had 6 sessions instead of 4? Just let us know and let us know if there's other topics that you think might be more top of mind for you, because we want to make sure that this session and this series is relevant to what you need in terms of your training, because we know that this is a hard enough job. So we want to make sure that we give you the resources and the tools that you need to make it just maybe 10% easier. All right. Thank you, Erin, and thank you to Maya for your support. Thank you to everybody who's indulging all my coughing. We made it.
Thank you so much. Have a great day, everyone.
Thank you.